Well, you come to Legal AF for breaking news. We got some now. California, as we predicted here on Legal AF, is filing an immediate lawsuit against the Trump administration for violating core principles of state sovereignty embedded in the 10th Amendment. We'll talk about that today. And violating the certain statute that Donald Trump is alleged to have used and is using in order to both nationalize the state National Guard, which he's not allowed to do without the governor's permission or through a governor order. That's already a violation. And since he hasn't invoked the Insurrection Act, and we already have a Posse Comitatus Act, which stops presidents from sending our military for domestic operations to a state, how is he sending 500 Marines through Pete Hegseth right now? A further violation of the sovereignty of California. And so Rob Bonta, who's the attorney general, who we just interviewed on the Midas Touch Network, is fighting back. He's filing that lawsuit for a violation of the 10th Amendment, for a violation of state sovereignty. And I'm going to talk about the case law and the statute that gives him wind at his sail. I like this case. It's a winner because of a long line of Supreme Court precedent. I'm going to break down for you right here to the molecular level, only on Legal AF. Let's get into it. We know what happened. Donald Trump, in order to make California look bad, to flame the fires, to put kerosene onto the impassioned feelings of people fighting against this immigration policy, because he wants the fight, because he's picking the fight, because he's baiting the fight, sent in the National Guard, but not just any National Guard, the California National Guard. Not that he protected them, not that he gave them any of the supplies they needed. He has them sleeping on hardwood floors with no cots, with no food, with no nothing, barely having any equipment. That's on Pete Hegseth. But leaving that aside for a minute, he tries to federalize, nationalize the state guard. You can't do that. There's only two ways you can do it. You either call an insurrection, and you invoke the Insurrection Act, which Donald Trump hasn't wanted to do as of yet. Or, in this case, you say you're using another statute, but you have to comply with that statute. That's Donald Trump's problem of being lawless. He never complies with the law. He doesn't believe in the law, except to his advantage. So 10 U.S.C. Section 12406, we call it the call-up statute, has to do with the National Guard being called up into federal service, which is what we're watching happen. There's only three triggering events. One, the United States or any state in the United States is being invaded or danger of invasion from a foreign nation. Take that one off the board. Two, there's a rebellion against the authority of the government of the United States. Come on. Basically peaceful protesting with a handful of rioting people, looting people. That's not a rebellion, as that definition has been set out by the Supreme Court, against the government of the United States. And three, the president is unable with regular forces to enforce the laws of the United States or execute on the laws of the United States. Where is there any evidence that ICE alone can't execute immigration law without having Marines, apparently, based on new reporting, and having the National Guard, the state guard, become the National Guard? And even if you had those three triggering events, the statute says that the president can only call up into federal service those members of the National Guard that he needs to execute the laws or to put down the rebellion. But all those orders have to come through the governors of the states. It's right in the statute. What are we missing? All of it. He doesn't have the triggering event. He doesn't have the governor call-up participation. How do I know? Because Gavin Newsom is very public that there was absolutely zero coordination with the governor's office, no pre-planning, hence the reason the California National Guard is sitting around on hardwood floors and or hard dank floors, no beds, and with no proper equipment. And so that didn't happen. So if that didn't happen, right there, we got a violation of the statute. Ultra vires, arbitrary, capricious, rogue. That's one basis for the lawsuit that's going to be filed within the next 24 hours. According to Rob Bonta, the Attorney General. The second basis is the violation of the 10th Amendment. That's why you hear Gavin Newsom talk about sovereignty. Our state sovereignty is being violated by the feds. See, we have a very complicated and complex federalist system. Our federalism system is very, very complicated. But Power can be given to the federal government by statute and by acts of Congress. But anything left over, this is the sort of the catch-all clause. Anything that falls off of that ends up in a repository of power for the states. This is how we got the states to agree to the new federalism. This is how we went from the Confederation of States to the United States Constitution, the United States of America. We had to make that deal. It's been there since the 1700s. Donald Trump doesn't care about it. Donald Trump doesn't remember why. He doesn't remember being taught about that. So the states have, and I'll read from you, the 10th Amendment, which is now going to be, you're going to know more about the 10th Amendment than you ever wanted to from the lawsuit that's just been filed. The powers not delegated to the United States by the Constitution, and that reference means the federal government, nor prohibited to it by the states, are reserved to the states, respectively, or to the people. It comes down to the states. It's their power. It's their sovereignty. And then there's a series of Supreme Court cases, which I want to talk about now. And this is why this case that's going to be filed by California is so on the money, because there's so many cases that exactly support their position at the United States Supreme Court level. It starts with cases that talk about the relationship between the federal government and the states. And it starts, we go back to the key cases. I would start with New York versus the United States in 1992. It's an anti-commandeering doctrine being established in that case. That we start with Congress. Congress, it was ruled, cannot compel state governments to enact or administer federal regulatory programs. You can't force them to do it. That's the baseline. Then we have Prince versus the United States, PRINTZ, which is in 1997, which extends that doctrine to the executive branch and the president. And it stands for the proposition that the federal government cannot commandeer state executive branch officials to enforce federal law. You can't make Gavin Newsom do what he doesn't want to do. And you can't put him in jail, which Donald Trump threatened from the White House lawn today, if he doesn't. That the president cannot direct state officers to perform federal law enforcement tasks, absent a statute. I already told you why the first statute doesn't work. And he hasn't declared anything under the Insurrection Act. So there is no statute. Absent a specific statute from Congress, the feds cannot do what they're doing right now in California. Then there's a case called National League of Cities versus Usury, partially overturned, but still has some very, very good law about the modern 10th Amendment analysis. Perpich versus Department of Defense, 1990, that's right on point. That's the definitive case about the federal government calling up the National Guard or taking control of the State Guard as part of the National Guard. There, the Supreme Court affirmed the domestic use of the Guard for law enforcement inside a state's triggering constitutional, says that triggers constitutional questions unless it is done, meaning 10th Amendment, unless it is done under a valid statute, and it's not. So when you put all these cases together, Donald Trump's goose is cooked, at least at the trial court level and the Ninth Circuit level, because we're in the Ninth Circuit for California, which leans heavily left or at least moderate. So here's my predictions. Lawsuit's going to get filed the next 24 hours. Come back here. We're going to have a couple of things for you here on Legal AF. One, an interview Rob Bonta just gave in real time to my podcast partner, Ben Meiselas, the co-founder of Legal AF with me. So you're going to see Rob Bonta, Attorney General, in real time talking about what he's doing with this lawsuit. Then you have this to guide you. Then the lawsuit's going to be filed, probably in the Central District of California, which covers Los Angeles. We'll get a judge. I'll report back on that in the initial proceedings. They'll sue for temporary restraining order to get the National Guard defederalized and out of California. And the Marines, apparently, under a violation of the Posse Comitatus Act. And then we're up and running with appeals, emergency appeals, United States Supreme Court. If you're the United States Supreme Court and you are planning to be in Europe for the summer, cancel your plans, because there's going to be a hell of a lot of emergency applications coming to you this summer, starting with this one. Until my next report, I'm Michael Popok. Can't get your fill of Legal AF? Me neither. That's why we formed the Legal AF Substack. Every time we mention something in a hot take, whether it's a court filing or a oral argument, come over to the Substack. You'll find the court filing and the oral argument there, including a daily roundup that I do called, wait for it, Morning AF. What else? All the other contributors from Legal AF are there as well. We got some new reporting. We got interviews. We got ad-free versions of the podcast and hot takes. Where? Legal AF on Substack. Come over now to free subscribe.